SJC-13081 in the matter of an impounded case.
Okay, good morning. Attorney Talley?
Good morning. May it please the court, Karen Talley on behalf of the appellant. People with serious mental health issues can enter the system through the door marked civil or the door marked criminal. Sometimes it depends merely on their zip code or even the color of their skin. Yet as this case demonstrates, it can affect whether and where they get adequate mental health treatment. This case involves the commissioner of the Department of Correction being able to override the decision of a court to place the respondent, civilly commit him to a Department of Mental Health facility. There are three possibilities if this court is inclined to construe the statute in a way that avoids some of the serious constitutional issues raised. So I will start there. There are three possibilities that are outlined in the various briefs. The appellee's reply brief posits that one possibility would be to construe the language in the statute about notwithstanding the court's failure to find that commitment in strict security was required, then the commissioner can act. One interpretation might be to construe that language literally as a sort of fail-safe where the commissioner can come in if the court has not considered those elements that relate to strict security.
Mr. Talley, can I ask you a question, please?
Yes.
When I look at the plain meaning of the statute, and we have confinement to Bridgewater State Hospital, as you point out with those four criteria, when you read the statute, the certification is if it's necessary to ensure continued retention in custody. So it speaks to me, at least, of what we call elopement, or as you recognize in your brief. As I look at the strict security and the other criteria for commitment to Bridgewater State Hospital, confinement in the possibility of elopement is not one of those. So can you address that? And this is particularly pertinent to your separation of powers issue?
Sure, yes. You're correct in that the statute talks about strict security in terms of determining whether the person is not an appropriate candidate for any other Department of Mental Health facility. So our position is that it's intrinsic in the statutory finding that the court is required to make. In other words, in order to find that the person is not an appropriate candidate for a DMH facility, the court is forced to consider the primary differences between DMH and
Well, it could be that the person is dangerous, not necessarily an escape risk, right? And we'll put aside whether or not there's any evidence of that here, and also your due process argument, which we'll get to.
Right.
But if you read it narrowly, and I get what you're saying, that included within the strict security is a consideration of the possibility of elopement. That's your argument for Article 30?
Yes, and it's more than that, but I'll address your question first. Yes, as we talked about in the brief, and as the parties agree, the main differences between DMH and Bridgewater relate to the secure perimeter and the lack of any access to the community. And so even when you're considering dangerousness to other persons or likelihood of serious harm that requires the strict security, again, that's in relation to whether DMH can equally prevent that harm and access to the community. So it's dangerousness or likelihood of serious harm within the confines of DMH, but also if the person were to escape and to elope. And as I think you noted, it was the case here that the court very clearly considered elopement. There was testimony.
Right. I think that record is solid, but our duty is to construe statutes if we can constitutionally, right, and also to conform to the will of the legislature, if at all possible. Is it possible to narrowly construe the statute to say that the commissioner's ability to certify is limited to that very narrow issue of the possibility of elopement?
Not in the sense that she can come behind the court when the court has made the determination that a DMH facility, which again, one of the primary differences is the perimeter security, is sufficient to prevent a likelihood of serious harm. And the finding of the need for strict security is considered by the judge. I would also point out, and this is getting a little bit into the separation of powers argument, is that nowhere in the mental health statute, or in fact in any of the general laws, does the commissioner have the power to send anyone, transfer anyone, much less commit anyone for a year to any mental health facility, Department of Mental Health or Bridgewater, accepting this provision in the statute. And that includes even the initial transfer under 18A. So a person who's in charge of a place of detention, if they believe that the person in their custody needs mental health treatment, and presumably it's an emergency, it can't be addressed at the facility, a clinician is called in to evaluate the person. And even if that clinician at the place of detention determines that evaluation under 18A, either at DMH or Bridgewater, is necessary, a court
No,
still
I
has to-
know. We're familiar with the statutes. So rather than waste your time, that's very valuable. Let me ask you a different question, please.
Sure.
The next question I have has to do with the substantive due process issue. Can you explain to me if we've ever reached, because all the substantive due process cases that, and I read them all and am familiar with most of them, they all deal with custody versus no custody, their bail, their initial determinations. Here we have a substantive due process claim that's built upon the differences between Bridgewater and DMH. Have we ever gone so far as to find this a violation of substantive due process? Are you asking us to expand our jurisprudence on substantive due process?
I'm asking for, in the context of a commitment, and I'm not aware of a case that compares the additional constraints on physical liberty between Bridgewater and DMH in this context, and squarely says that that's an additional substantive due process issue, a liberty interest that requires strict scrutiny. However, in this case, we assert 3 additional due process liberty interests that require strict scrutiny. One is the additional physical constraints on liberty that Bridgewater involves. The second is a liberty interest created by the statute itself, which requires or creates an expectation that a respondent will not be committed to Bridgewater absent the additional finding of strict security beyond a reasonable doubt. And third, that the stigma associated with a commitment to Bridgewater is an added liberty interest. And this court has addressed the issue of stigma, not in this context necessarily of substantive.
We've done it in procedural due process, not in substantive due process, correct, for stigma?
Most of them relate to, the more recent ones relate to the mootness on appellate review, and matter of a minor, I think, came closer, but yes, it was probably still procedural due process, but it was discussing the impact of a commitment on future employment prospects, future commitments, and things like that. So
Thank you, Ms. Talley. Those are all the questions I had.
Can I ask you to go back to Justice Gaziano's first question, which was, where in the statute do you see this risk? Does the judge need to find the risk of continued retention that Bridgewater is required in order to ensure his continued retention in custody? Where is it that the judge is making that finding? Because it seems to me one of the things you are arguing is that the commissioner is usurping or overriding the decision of the court. And I'm wondering when the court decided that it was necessary to ensure his continued retention in custody, a commitment in Bridgewater. Where is that in the statute?
Like I said, it's intrinsic to the statutory language.
Where is it intrinsic in the statute?
where it says that commitment to Bridgewater shall not be ordered unless the person is not an appropriate candidate for the Department of Mental Health.
So you're not relying on the strict custody would create a likelihood of serious harm element? You're relying on the other element that such person is not a proper subject for commitment to any facility of the department?
I think both of them, when you read them in tandem, and certainly.
All right, but let's stick with the strict custody would create a likelihood of serious harm. The statute defines likelihood of serious harm, right?
Correct.
All right, and so where in that definition of likelihood of serious harm do you find the risk of elopement assessed by the court?
Because again, if the main differences between the two types of facilities is the perimeter security, and the additional perimeter security of Bridgewater is deemed, as it was in this case, not necessary to prevent a likelihood of serious harm, then that's where I'm saying that it's intrinsic to the statute that the judge is finding that the lesser perimeter security, which is in the view of DOC, is going to create an increased risk of elopement. It's not simply a likelihood of serious harm to the individuals in the facility. It's a likelihood of serious harm that cannot be contained by the lesser perimeter security that DOC alleges that a DMH facility has. So it is not, you're correct in that it's not explicit. We believe it's intrinsic to the court's decision about whether strict custody is required, and that in this case, it was explicitly considered.
Serious harm or is not necessarily equivalent with issues involving a risk of flight. It's just not the same. And so retention might involve a completely different evaluation than what's required under 18A.
It's certainly possible that an individual could create a likelihood of serious harm that was not necessarily related to a risk of elopement. But in the agreed upon statement of facts, both parties agree that in these cases, the judge typically has bail information before him or her, understands the nature of the charges, has specific testimony about the risk of elopement. So that is, if not, clearly written in the statute. I understand that I'm saying it's intrinsic to the statute, but both parties agree that that's part of the focus of strict security, whether or not the person needs the strict security of Bridgewater. And I'm sorry if I'm not answering the precise nuances of the question. Feel free to let me know if I'm not.
Well, it just is that your assumption is that the risk of elopement is baked into the likelihood of serious harm. And I think the point that I'm suggesting, is that the two are different. And that while the parties may agree as to any particular facts they want to, our job is to construe the statute constitutionally. And where the judge makes one finding and the commissioner is allowed to certify something else, it seems to me there is not a direct conflict.
Well, I think on this, and I think that gets to the separation of powers issue. And again, I think what you have here is, yes, the DOC is arguing that they are two separate decisions. But again, that would require that the analysis under the separation of powers is that it's not a core function of the judiciary as opposed to a core function of the Commissioner of Correction. This is not akin to the core function of the Commissioner of Correction to make classification decisions and to transfer a sentenced prisoner to any facility she deems necessary for security. This is a commitment, to a one-year commitment that the Commissioner is making after the court has already ruled. And it does amount to a nullification of the court's ruling, similar to the case of Department of Revenue versus Jarvan Pa, which was cited in the DOC brief. And it says, we agree that the separation of powers principle bar the Commonwealth and its agencies from relitigating an issue that was contested between the Commonwealth and the defendant and resolved by a judgment in the defendant's favor. And that's what is happening here. This is not a separate issue of security that is within the commissioner's purview. And I would just add that the amicus brief that was filed by Mental Health Legal Advisors Committee and the Disability Law Center and the DBA notes that even as a practical matter, the Commissioner of Correction no longer has the kind of expertise and information about the day-to-day running of Bridgewater.
So you're saying that implicit in the judge's decision when he finds that DMH is sufficient is a finding that that he won't flee. I'm trying to make sure I understand that. Is that what you're saying? That implicit in that is a finding that he can be kept at in a DMH facility and he'll show up in court?
Yes, because the likelihood of serious harm is not confined to just a danger posed to the people within the DMH facility.
Is that because if he flees, he's no longer going to be in a DMH facility, so he will therefore be a danger to himself? I'm just trying to understand the logic of that. Yeah.
Well, again, we can presume that most cases involving strict custody involve a danger to others, or if the commissioner is, asserting her
But we don't have, we're finding here you're relying on the fact that the judge didn't find the need for strict custody, right? So the DMH facility was adequate, right? You're arguing the opposite, right? That we don't need a DMH. I mean, all we need is a DMH confinement. We don't need a Bridgewater confinement, right?
Yes.
So,
yes.
And you're saying that when the judge does that, that's an implicit finding of something related to custody. I'm just trying to.
Yes, and again, it goes back to the primary distinction between the two facilities being the level of security and the level of perimeter security.
Can I ask one follow-up question? So if we don't agree with you on that there is, as Justice Gaziano was saying, there's a difference in the finding, why isn't certiorari review of that sufficient to satisfy procedural due process?
Well, as I understand the certiorari review in the cases that were cited in Bridgewater's brief, there has to be some type of process, some type of record, some type of guide to the discretion to be reviewed. That most of the cases either are an administrative adjudication or at the very least some type of written decision. I don't know how a court would review for abuse of discretion when there's no policy, there's no procedure, there's no criteria or decision.
If we posit that it's limited to a decision on custody, not on dangerousness or anything else, and then you would analyze the person's risk of flight, I take it you could do that with the commissioner. To override needs to make that finding, right? That there's a risk of flight, right?
Presumably, but the reservation and report in this case specifically asked the department to produce any documents, policies, anything relevant to the certification process.
So then we would reverse it if they didn't have any support for it. So would the single justice review satisfy procedural due process of that? I'm not saying that's a great process, but I'm just, if I would assume that we're not going to be ignored that many, judges aren't going to be ignored that many times. And if it's an isolated incident and you have certiorari review, that's not going to be sufficient to your views. Well, I'm just trying to make sure I understand why.
Sure. And that's because all we have in this case is a certification, and the certification simply is a bare bones, and I can read the precise language. I hereby certify, it's a fillable form, a boilerplate form that you fill in the respondent's name. If ordered,
that doesn't mean we're going to approve that. We could write you a decision that says, if you're going to override the judiciary on a custody issue, you need to make specific findings on flight risk and have us address that. I mean, then you're going to have a standard out there, right?
If there was something that was adopted by this court or written into the statute that created a standard that has some criteria, ideally, it would permit some kind of input by the respondent as well. But yes, it would have to be much more than what currently exists to satisfy any procedural due process and even review. I mean, as it stands now, the commissioner override gives the commissioner more authority to review or to reverse a decision of the district court than even this court has. This court is bound by the factual findings.
Okay,
there are-
thank you, Attorney Talley. Did that answer your question, Justice Kafker?
Yes, I'm. all
Does
set.
anyone
Thank
have
you.
any further questions?
No.
Okay, thank you so much. Attorney O'Donnell, please.
Good morning, Your Honors. May it please the court, Ted O'Donnell for the Commissioner of Correction and the Superintendent at Bridgewater State Hospital. The Commissioner's certification provision in Section 18 does not in any way violate the Constitution or the rights of the inmates to whom it is applied.
Is it reviewable at all?
I would suggest not, Your Honor, and I'll say.
So how can it be constitutional if someone's going to be committed involuntarily for a year and there's absolutely no review?
It is such a core function of the commissioner as an executive branch officer to ensure the retention and custody of an inmate who's either serving a sentence or held
Can you
awaiting trial on
can
bail.
you tell me any other provision in Chapter 123 that's not reviewable?
No, I would say this is an island in the sea of reviewable things. And for good reason, Your Honor. There are distinctly different things. So I think the other side is mischaracterizing what's occurring when they call it a commissioner override. It's really not.
That's all labeling. I mean, you know, that's we'll get past the labeling. Let's get into what actually happens.
Sure. So everything happened, everything unfolded exactly as the legislature intended as it set out. And so by way of explanation, so there's a Section 18 petition filed for the individual.
Well, let me ask you something about everything unfolding perfectly. We have a hearing. There's actually one question asked about elopement, i.e. escape, not an issue whatever in front of the judge. If we read the statute narrowly, like you ask us to do, the judge says DMH, it goes in front of the commission. The commissioner says, no, there's an elopement issue. Again, if we agree with you, and the person's committed for a year. How is that the way it's supposed to be if there's zero evidence supporting the finding of the commissioner and it's not reviewable?
Sure. So the way it occurs is the case is presented in front of the judge. The judge finds beyond a reasonable doubt that the individual is mentally ill and requires a period of involuntary hospitalization not to exceed the expiration date. Now, just a word on that. The order, such as it is, the person can be discharged at any time without any further court action. So while it is a commitment order, there is that quality to it. Now, the court was not persuaded beyond a reasonable doubt that due to his mental illness, the individual required the strict security of Bridgewater. The court then was left only with the option of committing him to a Department of Mental Health facility, and so the order was. Then the commissioner, looking strictly at, excuse me, the retention question. Here's a person, there's no contest, he has the bail status that he has. The commissioner, as the executive officer, required to retain people in a secure setting, did so in this case. And why would the legislature,
Based on what?
Right.
based on his having the custody status that he has?
Okay, so no, but why is that's the problem I have. The commissioner's making a determination. And you know, in Article 30 is not airtight compartments, but the commissioners make a determination of elopement risk. We had a hearing. We don't know why the commissioner is making this determination. And unlike anything else in Chapter 123, you're telling us it's not reviewable.
I suggest,
Isn't that a due process concern?
no, Your Honor. I suggest there's no fundamental liberty interest involved to warrant a due process question as to whether the inmate receives a psychiatric treatment at this versus
Are you
that
talking about
facility.
procedural or substantive due process?
I suggest there's no due process involved in this matter, and let me explain. So at the time the individual is either sentenced or has a bail set, he has that due process. At the time he is civilly committed, he has that due process. And so all we're talking about is whether he receives his psychiatric care at Bridgewater, where he will be securely retained for the duration of the period, or whether he should receive his psychiatric care in a less secure Department of Mental Health
Well,
facility.
Counsel, can I interrupt you on that one point? As you were going through what happened here, the certification process comes after the full hearing where the burden is beyond a reasonable doubt.
Yes,
So the certification process isn't self-executing, right? Because it has to be contingent upon a finding that the patient needs the strict security of Bridgewater. Would you agree with me on that?
well, in this case, that wasn't,
That's why I'm saying, that's why I'm asking you, because if you look at the certification process, there's an and that comes just before that relates to the sentence right before. And it would seem to suggest, at least to me, this is just on the statutory construction part that I have the issue with, going back to Justice Gaziano's question to your sister. If the judge doesn't make a predicate finding that the patient needs the strict security of Bridgewater, does the commissioner even have the certification authority?
if the court is basing its finding on the mental illness factor, and the commissioner, it's a different.
No. I understand that that's how you're trying to construe it, but I'm saying that the sentence right before the and, doesn't it say that there needs to be a finding before we even get to certification that the petitioner requires the strict setting of Bridgewater?
No, Your Honor, I don't believe that is.
It doesn't say that when it says the prisoner shall be confined at said hospital if the findings required for a commitment to a facility are made.
Yes,
Speaking
and
of
that's, when
Bridgewater.
it says to a facility, it means DMH. So it falls short of that, it falls short of that Bridgewater strict security piece. It's, whenever they use the word facility in 123, they mean DMH.
Well, I'm just, again, I'm trying to just understand, because if you go back, if I didn't read the fuller sentence, to make a finding required for commitment to the Bridgewater State Hospital, the prisoner shall be confined at said hospital if the findings required for a commitment to the facility, to a facility are made. So you're saying any facility?
To DMH, yeah. So in other words, the way the
Okay.
statute is written is the person is found to be mentally ill, so subject to an involuntary commitment period, to require hospitalization. And then that third piece is the one that would be missing, where if they have a custody status, then the commissioner may weigh in and say, I certify this hospitalization should take place at Bridgewater as opposed to DMH.
Mr. O'Donnell,
I'm sorry, go ahead, Justice Lori.
in the statute, as you know, there's a requirement to certify to the court that the confinement is necessary. So the legislature contemplates court involvement, certify to the court. So let's go back to Justice Kafka's question. Why doesn't that, at a minimum, mean certiorari and abuse of discretion review, at a minimum?
It's really such a core function, I would say, in
It could,
looking-
okay, I appreciate that. Maybe put the constitutional issue aside from it. Maybe the legislature didn't have to say that, but they did. They decided it wasn't such a core function. They said it's a core function that requires certifying to the court. That's what they wrote. Why doesn't that require at a minimum certiorari review?
In looking at a court review of why the commissioner would determine that someone that is either serving a sentence or has a bail, why that person can't instead be somewhere else, that really intrudes, I would suggest, too far into the executive branch. And I say, really, it would be an improper encroachment. So
You're
My first-
arguing Article 30 now.
yes, Your Honor.
Are you done, Justice Lori?
Yes, thank you.
So what you're intimating to us is that the the commissioner is going to certify, because this criteria is mysterious, the commissioner is going to certify in cases where the person is being held at DMH over the commissioner's objection by a judge, and now the person also has some type of bail or custody status. Is that what you're telling us?
Yeah, only in those instances, only a Section 18. This
There's
does
no,
not
there's no
come-
regulation, but the practice you're telling us is when someone's held on bail to certify so that they go to Bridgewater.
Yes, if they have a custody status, only on a Section 18. This does not come up, there's no allowance in a 7 and 8 commitment, a 16 commitment.
No, I know we're talking about 18A.
Yeah.
Exactly.
Yeah.
So, okay, so that's the criteria that really underlies this is
Yes,
is the
and I
person's bail
suggest that-
status.
And I suggest the reasoning, the legislature fully
Is
knowing,
that written down anywhere, or is that just practice,
it is the evolved practice, Your Honor.
evolved practice?
There is no written regulation. It has evolved.
Okay, thank you, that clarifies.
I
The
still can't figure out. So we've got the commissioner deciding that the petitioner needs to be in a much more secure environment, essentially in a prison. This is not a choice like between prison A and prison B, like that we give some deference to the commissioner. This is basically, we've got the commissioner deciding that something the judge thought was not necessary on a different ground. And you're saying there's no review whatsoever of that? That just seems, you're just inviting due process problems, particularly when you're taking someone from a DMH facility and putting them in in Bridgewater, which is, let's face it, it's a prison. So you really think that that's going to survive a procedural due process review without any form of appellate review? I don't think they're that empowered to do stuff like that.
Well, I suggest, Your Honor, that the location of the hospitalization is not something that should warrant
This is not
further due
cell block
process
A.
than the
This is
person.
not,
Right, but
this is
counsel,
not cell block A versus cell block B.
right.
This
And-
is not one maximum security prison for another maximum security. This is a big difference done after a judge has decided it's not necessary for reasons that at least implicitly deal with elopement. I just
And
think you're
doesn't it
asking
just
for trouble.
seem unfair? Isn't it just unfair?
I suggest not, Your Honor. And the reason I say that is a person having a custody status doesn't have a reasonable expectation of being in the community during the time they have a custody status. So whether they're serving a sentence or being held on bail awaiting trial, there's no reasonable expectation that that person should harbor that they'd be allowed access to the community during that time period. That's why I don't believe it's fundamentally unfair.
But if
Yeah.
when you read the procedural due process cases, and as Ms. Talley indicated, we found procedural due process, liberty interest, and and how much process is due depends on the balancing, but we found it based upon stigma. We found it based upon differences in custody, time spent in custody. And again, it may not rise to substantive due process, but haven't we found procedural due process concerns, a liberty interest, and other similar deprivations of liberty?
It's hard to have an analogous situation, Your Honor. It's kind of a unique situation that we're presented with here. If the person is serving a sentence, any stigma is already attached to that. So there should be no further the fact that they happen to be hospitalized while they're getting psychiatric care at Bridgewater versus a Department of Mental Health
But
facility.
it's a huge difference to be walking around at Taunton with grounds privileges versus being locked up at Bridgewater, right?
Yeah, absolutely, Your Honor. No question. It's night and day.
Right.
Yeah, no dispute.
And that would lead to procedural due process protection, wouldn't it?
It's,
Especially here where the record shows that there was no risk of elopement, and now suddenly it's certified that he needs the Bridgewater in order to maintain him in custody. Like, it just seems that not allowing a procedural due process procedure is problematic. And in fact, as Justice Lowy was pointing out, perhaps that's why the legislature thought fit to say he must certify or she must certify to the court. It seems to me that would be helpful to you. I don't know why you're resisting.
A
And
review
to
process.
salvage the statute. Otherwise, you've got a procedural due process problem.
Well, as I had posed as an alternative in the brief, should this court find that there is a review that's, necessary, proper, then the certiorari was the option that I felt would probably best meet the need. My first statement, as I indicated, was.
But as your sister said, there's no process by which the certification, what are we to review? Other than just an order coming down saying, I'm invoking my authority under 18A in the certification and I'm committing the person back to Bridgewater. There's no process for us to review.
That's true, Your Honor, and that was part of the reasoning why I felt that another complicating factor to having a review process is to how, the commissioner, it's a fact, there's no dispute, he has a custody status. So it's not an arbitrary and capricious type decision by the commissioner to say, because of the custody status, his psychiatric treatment should be at Bridgewater versus DMH. That's essentially it. There's not a lot, to go on beyond that. It's essentially that. So if there were no custody status, perhaps, that would be.
Why couldn't we review your decision as arbitrary and capricious? You didn't bring it to the judge that there was any elopement issue. There wasn't any, there's no support for it in any piece of paper you put out. We don't let you do things by fiat. Why can't we just use our certiorari process to reverse what you did? Because you don't have any basis for it. Why can't the certiorari, that's what certiorari works for, things that are hard to define.
Well, certainly if the court, and it sounds like from your questioning that you're inclined, the certiorari review going forward.
Well, we're inclined not to let you do whatever you want for no reason whatsoever. That's a due process violation.
Yeah, we're not, I wouldn't hold out that we're doing whatever we want for no reason. It's all custody status based. There's no reason, but that's essentially it.
It's not the only tool, though. It's not the only tool, though. There's also Section 13.
The difficulty with that, Your Honor, is when someone gets returned from DMH on a Section 13, the only thing we can do is file a 7 and 8 within 5 days. And the 7 and 8 doesn't get you any assistance. So if someone comes back to us as an 18 because they failed, say they escaped or something and they got caught from DMH, get returned to us, we have a 7 and 8 only option. Now we could move to amend it to an 18, which might or might not be allowed by the court we are appearing in front of, but it's certainly not a read you can hold on to and rely upon.
Okay, does anyone have any further questions?
Thank you, Chief.
Okay, thank you very much.
Thank you, Your Honor.
Counsel.